Why medical injuries are a distinct class? First, the parties involve physicians and patients, and the yardstick is standard of care. There are four elements that are essential to prove medical negligence: duty, breach, injury, causation, which may give rise to criminal, civil, or administrative cases. This discussion centers on the physician-patient relationship, the cornerstone of any medical malpractice case. So it defines when a doctor's legal duty begins, how long it continues, and when it properly ends. Without this relationship, there is no duty to breach and therefore no malpractice liability. The physician-patient relationship is both professional and fiduciary, built on trust and confidence. It creates the physician's duty of care, the first element of any malpractice claim. Legally, it's considered a special contract, not necessarily written, but binding once the physician accepts the case. This acceptance may be expressed through a formal consultation or implied when the doctor voluntarily provides care or advice. The relationship begins the moment a physician takes responsibility for diagnosis or treatment, even momentarily. It may arise from a hospital admission, outpatient consultation, or even informal advice during an emergency. Once this occurs, the physician is legally bound to apply reasonable skill and diligence consistent with professional standards. In practice, this relationship is proven through documentation, such as progress notes, admission records, prescriptions, or diagnostic tests, which show that professional care was rendered. It defines when a doctor's legal duty begins, how long it continues, and when it properly ends. Without this relationship, there is no duty to breach and therefore no malpractice liability. The relationship continues until the physician properly terminates care. This may happen through safe discharge, formal referral, or the patient's informed refusal. A proper handoff ensures continuity of care and protects both the doctor and the institution. If a physician abandons a patient without notice or referral, especially in critical stages, the law considers that professional negligence. In investigations, the absence of a signed discharge summary or referral letter is often decisive evidence of abandonment. In hospital settings, determine who holds the duty can be complex. Private physicians contract directly with their patients, but hospital-based or accredited doctors can make the institution jointly liable under the doctrines of ostensible agency, corporate negligence, or vicarious liability. The physician-patient relationships defines the scope of a doctor's legal and ethical responsibility. Once established, the physician's acts are measured against the standard of care. A well-documented relationship, clear notes on admission, transfer, and discharge often determines whether a case prospers or fails. For doctors, documentation is the first line of defense. For lawyers, it is the first layer of proof. Every malpractice claim, whether criminal, civil, or administrative, begins and ends with the proof of this relationship. For the standard of care, we're going to discuss the following: its definition, the presumption, the burden of proof, exceptions, and justification for non-adherence. In medical negligence, the standard of care refers to the skill, care, and judgment that an ordinarily competent physician would exercise when faced with similar circumstances. The law does not demand perfection. It expects reasoned medical judgment consistent with what peers of similar training and experience would consider acceptable practice. This means the physician's conduct is always measured against peers within the same specialty, resources, and context. For instance, an ER doctor managing a trauma case is judged by emergency medicine standards, not by the expectations for a cardiologist or surgeon. Similarly, a provincial hospital's limitations are considered when compared with tertiary centers, as long as reasonable diligence and proper referral are observed. The benchmark is reasonable competence, not infallibility. Adverse outcomes or honest errors of judgment do not automatically amount to negligence if the physician's decisions were based on sound clinical reasoning and available data at the time. Courts recognize that medicine involves uncertainty, and the test is whether the doctor acted as a prudent professional, not whether the result was ideal. Finally, the standard of care is anchored on accepted medical practices and guidelines prevailing during the treatment period. This may include DOH circulars, specialty society protocols, institutional policies, and recognized clinical literature. In litigation, expert witnesses rely on these sources to define what competent care required and to show whether the accused physician's actions fell below that threshold. In Philippine law, a doctor is presumed to have exercised due care and professional competence. This flows from the general presumption that every person acts in good faith and with ordinary diligence. It protects physicians from unfounded accusations simply because a treatment ended badly. However, this presumption is not absolute. It remains in force until credible evidence shows otherwise, such as a proof that the physician's act or omission departed from accepted medical standards. Once the patient or complainant presents expert testimony or reliable hospital records showing a likely deviation, that presumption is overcome. The burden of proof therefore lies with the plaintiff. The physician doesn't need to prove perfection, only that the care given was consistent with the standard of a reasonably competent practitioner in similar circumstances. In practice, accurate documentation, informed consent, and adherence to clinical protocols are the best ways for physicians to preserve this presumption of due care. Burden of proof. The plaintiff, as I've said, bears the burden of proof. It may be overcome by proving the following elements of malpractice: that the physician owed a duty of care to the patient, that this was breached, the breach caused injury, and that actual damage resulted. The doctrine of res ipsa loquitur, meaning the thing speaks for itself, allows the court to infer negligence from the very nature of the injury. It applies when the event is one that would not normally happen if due care were used. For example, a surgical instrument left inside a patient after an operation. When this doctrine applies, the burden of explanation shifts to the physician, who must show that the injury occurred despite ordinary care. But this rule is used sparingly. It only operates if the injury is unusual without negligence. The instrumentality was under the doctor's exclusive control and the patient did not contribute to the harm. In short, res ipsa loquitur is an exception, not the rule, a tool for the court to recognize clear negligence even without direct expert proof. So these are the cases where res ipsa loquitur was applied. And these are the cases where it was not applicable. So when is the strict non-application of the standard of care justified? So there are several contextual variables that influences this. First, in emergency conditions, judgment errors made under extreme time pressure may be excused if the doctor's actions were still within reasonable medical bounds. The law recognizes this through Republic Act 10932, the Anti-Hospital Deposit Law, which prioritizes life-saving care over procedural perfection. Second, how these variables justify non-strict application. The patient-specific factors. No? The rationale is standards must adapt to the patient's unique condition, history, and expressed choices. The effect here is a doctor who adjusts or withholds treatment because of allergies, comorbidities, or informed refusal is not negligent. Deviation is justified if properly explained and documented. So for example, withholding a radiologic test in a pregnant woman due to fetal risk or modifying dosage in renal impairment patients. Institutional limitations occurs when the law does not demand performance beyond what a facility can reasonably provide. So here, a physician, for example, in a level 1 hospital lacking a CT scan or an ICU is held to a contextual standard. Did the doctor recognize the limitation and refer or transfer promptly? For geographical or technological differences, in rural or remote settings cannot be judged by urban tertiary standards. Courts accept reasonable reliance on clinical acumen and basic diagnostics, provided the physician remained vigilant, prudent, and communicative with the patient or referral centers. Institutional limitations also shape expectations. In every situation, what protects the physician is reasonable decision, making a thorough documentation that clearly explains why actions differed from ideal standards. How to use this as a defense? To effectively defend a medical negligence case where strict standards couldn't be followed, The physician must first prove context. Show the court that there were genuine limitations beyond your control. For example, no available CT scan, no blood supply, or lack of transport during an emergency. Supporting documents like hospital certifications, logbooks, or affidavits from staff help establish this factual backdrop. Next, show reasonable substitute action. The goal is not perfection, but prudence. Demonstrate that you did what a competent physician would have done given the same constraints. You stabilized the patient, sought alternatives, or referred to a higher facility. Then, ensure documentation. Write down what was missing, what actions you took, and when. Include referral notes, calls made, and patient or family communications. Proper documentation transforms apparent failure into evidence of diligence. Finally, invoke the contextual standard. Argue that you acted reasonably within the environment and resources available. Courts judge conduct by reasonableness, not by ideal conditions. A well documented contextual defense often persuades the court that the doctor acted conscientiously despite real world limitations. How the defense prove adherence to standard. You have to document every decision. So that's the first rule. Document everything and document it well. Medical records are the physician's strongest shield because they preserve the reasoning behind every clinical action. Each note should explain not just what was done, but why it was done, the assessment, the options considered, and the basis for the decision. Entries must be legible, dated, and contemporaneous, meaning written at the time of the event, not reconstructed later. Courts give immense weight to authentic, timely records. Conversely, missing, inconsistent, or post-dated entries create suspicion and can imply negligence or concealment. Remember, if it isn't written, it's presumed not done. A complete, coherent chart often speaks louder than any courtroom testimony. To prove adherence to the standard of care, the defense must anchor its position on recognized protocols and institutional standards. This means presenting the hospital's internal policies, DOH licenses, and specialty accreditation certificates that were in effect when the care was rendered. These documents confirm that the institution and its staff were operating within a regulated, quality-controlled environment. The physician can further demonstrate diligence through evidence of continuing professional education, regular peer review, and clinical supervision. By doing so, the defense shifts the discussion from individual error to systemic compliance, showing that the doctor's actions were consistent with both hospital and national standards, not arbitrary or reckless decisions. The next pillar of the defense is the expert witness. Courts rely on experts to define the standard of care and to evaluate whether the physician's actions were consistent with good medical practice. Defense experts should be from the same or a closely related specialty, actively practicing in a comparable settings. Their testimony should illustrate that the accused physician's management decisions were reasonable, accepted, and medically justified. A credible expert doesn't simply defend, they educate the court, explaining that medicine involves judgment, uncertainty, and individualized decision making. By framing the physician's choices within the spectrum of accepted practice, the expert shows that the outcome, though unfortunate, was not the product of negligence but of a reasonable exercise of medical judgment. Even if a deviation is alleged, the defense must show that the supposed lapse did not cause the injury. Causation is the bridge between mistake and liability, and breaking that bridge is often decisive. The defense can present evidence that the harm stemmed from an independent, intervening, or unavoidable cause, such as a patient's underlying condition, a natural disease progression, or an inherent risk of treatment that was fully disclosed through informed consent. For example, a post-operative infection might occur despite sterile technique, or a cardiac arrest might result from a pre-existing heart disease rather than anesthesia management. The goal is to prove that, even assuming deviation, the injury was not a foreseeable or direct consequence of the physician's act. Once the causal link is severed, negligence cannot be sustained. So these are the practical checklists proving the standard of care. What are the elements of medical malpractice? So as I have said before, there are four elements: duty, breach, injury, and causation. A physician's duty of care starts the moment they engage in any act of diagnosis, advice, or treatment. So even something as brief as checking vital signs or giving preliminary orders in the ER. This establishes the doctor-patient relationship that I have talked about. And once that relationship exists, the law presumes continuity of duty. It remains in force until care is properly and ethically terminated, which may occur through complete discharge after ensuring the patient's condition is stable and instructions are clear, transfer or referral to another qualified physician or facility, and informed refusal of further treatment, where the patient, after understanding the risk, decides to discontinue care and signs an acknowledgement. If the physician stops attending without reasonable notice, it can be interpreted as abandonment. Even without a formal admission, a duty arises when a doctor voluntarily provides aid in an emergency. Hospitals and on-duty physicians cannot lawfully refuse emergency care under the law to a person in imminent danger. Refusal constitutes a separate administrative and criminal offense. So the physician's duty here is to provide initialing care, initial stabilizing care rather, and if necessary, arrange proper transfer once the patient is out of immediate danger. When care is transferred, the outgoing physician must provide adequate and timely handover of medical information to the receiving doctor or facility. The process of obtaining informed consent is not just a formality, but a part of the physician's duty to educate and respect patient autonomy. Courts view a well-documented patient-signed informed consent form, particularly, particularly with entries on risk, benefits, and alternatives as evidence that the physician exercised due diligence before treatment. Conversely, absence or poor quality of consent documentation can be used to prove breach of duty or ethical violation. Courts rely heavily on written and electronic records to determine whether the doctor-patient relationship existed and whether care was appropriate. So, key documents include admission and discharge records, progress notes of doctors, nursing notes, referral or endorsement forms, informed consent forms, outpatient consultation sheets and follow-up instructions, the electronic health records with date and time stamps, audit trails, and electronic signatures serve as modern proof of the duty's existence and continuity. Finally, hospitals and administrators have their own duty of corporate diligence. They must verify that all attending and visiting physicians are properly credentialed, licensed, and privileged to perform specific procedures. Maintaining updated credentials, files, peer review records, and training logs demonstrates that the institution exercised due oversight, a key defense against corporate negligence claims. A breach in medical malpractice occurs when a physician's act or omission falls below the accepted professional standard of care required under the circumstances. It is the failure to do what a reasonably competent doctor would have done, or doing something a competent doctor would not have done under similar conditions. Errors of omission. A breach of duty happens when a physician's actions or omissions deviate from the accepted standard of care expected in their field. This is not about a bad outcome. It's about whether the doctor acted as a reasonably competent practitioner would have done under the circumstances. For example, a failure to monitor vital signs after a procedure may appear minor, but in practice it can mean missing early signs of deterioration such as bleeding, infection, or airway compromise. Courts view such lapses as evidence of inadequate vigilance, one of the most common bases for negligence findings. Similarly, a failure to refer the patient to a specialist when the case exceeds one's expertise reflects a disregard for professional limits. The standard of care expects a physician to recognize when specialized management is required. Lastly, a failure to order confirmatory tests, whether laboratory work or imaging, shows poor clinical judgment. A reasonably competent doctor investigates warning signs before ruling out serious medical conditions. In all these examples, the breach lies not in the decision's outcome, but in the failure to act with the prudence and diligence expected of a professional under similar clinical conditions. Breach of duty can also arise from errors of commission. When a physician performs an act that no reasonably competent doctor would have done under the same conditions. For example, a wrong dosage, wrong drug, or use of contraindicated medication demonstrates a lapse in clinical judgment and patient safety. Such mistakes often result from failure to review the patient's history, allergies, or concurrent medications. errors that are easily preventable through diligence and adherence to prescribing protocols. Performing an unnecessary surgery or using an unsterile technique represents a serious breach of both medical and ethical duty. These actions expose the patient to avoidable risks, infections, and complications, and they often indicate poor decision making or disregard of hospital sterilization standards. And finally, misinterpretation of diagnostic results, such as overlooking a critical lab finding or misreading an imaging report, leads to wrong or delayed treatment. Courts consider this a breach when it results from carelessness rather than an honest difference in professional opinion. In essence, these acts reveal a failure to apply the ordinary skill, care, and attention required of the profession. The key test remains: would a competent physician, similarly situated, have acted differently? If yes, a breach of duty exists. Failure of communication. These failures affect informed decision making, patient compliance, and an early detection of complications. Examples include failure to obtain informed consent, not disclosing material risk, alternatives, or the nature of the procedure. Legal breach under the doctrine of informed consent. The failure to explain the diagnosis or treatment. Misunderstandings about medications, follow-ups, or dietary restrictions leads to non-compliance and deterioration. Failure to notify results or complications, not informing the patient of an abnormal test results, or not warning about signs of adverse drug reactions or post-surgical risk. For provider-provider communication failures, breakdowns among clinicians can lead to disjointed care, especially in team-based settings like hospitals. Failure to hand off properly between shifts or transfers, omission of critical information in referrals, charting, or verbal reports, failure to escalate care. For example, nurse not notifying physician of declining vital signs. Another clear form of breach occurs when a physician fails to respond appropriately to a patient's worsening condition. The law and medical ethics both expect continuous vigilance and timely intervention once a patient is under a doctor's care. When a physician ignores deteriorating vital signs or symptoms, such as falling blood pressure, increasing heart rate, or difficulty breathing, it signals a serious lapse in monitoring and clinical judgment. Courts interpret this as negligence because a competent doctor would immediately investigate and act to prevent further harm. Delaying urgent intervention or transfer, for instance, postponing surgery or waiting too long to refer a patient to a higher level facility, often turns a manageable condition into a fatal one. The standard of care requires prompt, decisive action once instability is recognized. Continuing a known ineffective treatment despite clear evidence of failure also constitutes breach. Persistence in a failing regimen demonstrates lack of critical reassessment, which is central to competent medical practice. In summary, a physician's duty does not end with initiating treatment. It includes ongoing assessment, timely decision making, and readiness to escalate care when a patient's condition worsens. Failure to do so is one of the strongest indicators of breach in malpractice cases. So this is a table on common evidence. The evidence type, which are usually hospital records, the purpose, and what is the practical use. So in malpractice cases, documentation tells the story. Courts and review boards rely on the patient's chart more than on memory. What is written is presumed true, and what is missing is presumed not done. Medical records and progress notes reveal the physician's action and decisions throughout treatment. When entries are incomplete, altered, or inconsistent, they create an inference of negligence or concealment. A well-documented record, on the other hand, is a physician's best defense. Nursing and ancillary logs are equally important. This shows how often vital signs were checked, medications given, or laboratory results followed up. Gaps or missing data indicate lack of monitoring, a frequent ground for findings of neglect in both administrative and civil cases. Hospital protocols and DOH guidelines define what is considered standard conduct. Experts use these as benchmarks to determine whether the doctor acted within or below accepted norms. Compliance with institutional or government-issued protocols strongly supports a defense of due care. Medication orders and operative reports show the sequence of medical decisions, from prescription to surgical execution. Any deviation, such as the use of a wrong drug or a delayed order, provides concrete evidence of substandard practice. Finally, expert testimony and medical literature establish what constitutes accepted practice in the profession. They connect the documents to the broader medical standard and confirm whether the physician's act departed from recognized norms. In essence, every malpractice case rises or falls on documentation and expert interpretation. Together, they form the factual and scientific foundation for proving or defending against negligence. For prosecutors and complainants, success in a medical negligence case depends on specificity and evidence, not on broad allegations. The first step is to engage a qualified medical expert early. The expert's review will help identify the exact act or omission that constitutes the alleged breach, whether it's a delayed diagnosis, an improper medication, or failure to monitor. Without this early technical guidance, the complaint may remain too general and easily dismissed for lack of detail. Next, it's essential to correlate all available documents, patient charts, laboratory and imaging results, nursing notes, and hospital policies. Each document serves as a piece of the puzzle that shows whether the physician's conduct was consistent with institutional and professional standards. The alignment or discrepancy among these records often reveals the true sequence of events. Lastly, avoid vague accusations like the doctor was careless. Courts require specific factual basis for negligence claims. Instead, describe how the care deviated from the expected standard. For example, failure to order or repeat CBC despite dropping hematocrit, or failure to transfer the patient despite unstable vital signs. In short, clarity, evidence correlation, and expert validation are what turn a complaint from a mere suspicion into a credible, prosecutable malpractice case. For the defense, the key is to contextualize the physician's actions. Medicine often involves quick, high-stakes decisions made under time pressure or with limited resources, especially in emergency or rural settings. The defense must clearly present these circumstances to help the court understand that not every unfavorable outcome equates negligence. It is also crucial to emphasize that an error in judgment is not the same as negligence. Courts recognize that medicine is not an exact science. Even competent doctors can make difficult calls that, in hindsight, appear mistaken. What matters is whether the decision was made based on sound clinical reasoning and consistent with accepted practice at the time. Documentation of the doctor's thought process, the patient's condition, and available options becomes the strongest proof of prudence. Finally, the defense should present credible counter-experts who can testify that the accused conduct fell within the range of acceptable medical responses. These experts help demonstrate that the physician's decisions were reasonable and defensible, given the clinical facts and constraints. In summary, the defense strategy is to show that the physician acted competently, not perfectly, that the choices made were medically justified, responsibly documented, and consistent with what a prudent practitioner would have done under the same circumstances. Hospitals and administrators play a crucial role in preventing medical negligence. Their responsibility goes beyond providing facilities. They must ensure that systems of care and supervision are in place and up to date. First, hospitals must maintain updated standard operating procedures that reflect the latest DOH regulations and specialty society guidelines. These SOPs define the hospital's expected standard of conduct and serve as the framework by which physician staff performance is measured. In medico-legal investigations, the existence of clear current policies is strong evidence that the institution exercised proper corporate diligence. Second, administrators should implement regular audits and documentation training for medical and nursing staff. These audits identify gaps in compliance, while continuous training reinforces proper charting, consent documentation, and referral practices, the very records that determine liability during litigation. A hospital that can show it has clear SOPs, trained personnel, and active monitoring can often avoid or mitigate liability even when an individual practitioner is found negligent. Ultimately, good governance and consistent documentation are the best institutional defenses against findings of breach or corporate negligence. So these are the cases on breach. Now let's go to injury. What is the concept of injury in medical malpractice? Physical injuries are the most straightforward to prove, yet they require meticulous record correlation. Hospital and outpatient records reveal how the patient condition changed over time, whether there was proper post-operative monitoring, whether infections were promptly treated, or whether complications were ignored. Operative reports, discharge summaries, and imaging results serve as chronological proof that something went wrong following treatment. Photos or videos of scars or deformities, properly authenticated, also help visualize the damage. The prosecutor or complainant must show that this injury was foreseeable, consequence of the physician's act or omission, not a random occurrence. Expert witnesses then connect the dots. Because the drain was removed too early, fluid accumulated and caused infection. Physical evidence supported by consistent charting is the most persuasive form of injury proof. To prove physical injuries, prosecutors rely on hospital charts, operative and discharge reports, and follow-up records showing deterioration after treatment. Imaging studies and lab results help trace how the injury developed. Even simple evidence like wound photos or mobility assessments can be powerful if authenticated. The key is to connect the timeline, when the doctor's act occurred and when the injury appeared. A well-prepared medical expert can explain this causal link in a way the court can grasp. Psychological or emotional injury is harder to see but equally real. Courts now recognize that malpractice can leave mental scars, fear of hospitals, depression after a traumatic birth, or anxiety following disfigurement. However, this must be backed by professional assessments. A psychologist or psychiatrist should conduct standardized tests and issue a report describing symptoms, duration, and functional impairment. Instruments such as the MMPI-2 or Beck Depression Inventory provide objective baselines. The evaluation must clearly tie the mental state to the medical event. For instance, panic attacks beginning after a negligent anesthesia episode. The lesson for both sides are clear. Psychological injury becomes credible only when validated, documented, and explained by a mental health professional. The presentation of injury evidence in court must tell a coherent story. The patient gives the human narrative, what changed in their body, work, or family life. The expert provides the scientific translation, how the medical act caused that change. Visual evidence like x-rays, operative photos, or medical timelines powerfully bridge the two. Jurists appreciate visuals that simplify complex pathologies. The key is organization. Start with the patient's account, corroborate it with the medical records, and seal it with expert explanation. Each layer builds credibility and leaves little room for doubt. For the defense, the goal is to break the causal link between the physician's act and the alleged injury. Not every bad outcome is negligence. Some are inherent risk of medical treatment. Defense experts may show that the injury resulted from the patient's underlying disease or non-compliance, not the doctor's care. A myocardial infarction after high-risk surgery, for example, may occur even under perfect management. Comprehensive and contemporaneous records are the strongest defense. They show that the physician acted prudently, monitored properly, and obtained consent regarding foreseeable risk. Counter experts can also highlight alternative causes or demonstrate that the treatment complied with accepted standards. Witness preparation determines credibility. The complainant must understand that their testimony should match the medical record exactly. Inconsistencies, even minor ones, create doubt. They should focus on describing concrete experiences, pain, disability, fear, in practical terms. Statements like, "I couldn't lift my child for 3 months," are more believable than vague claims of severe suffering. Counsel should rehearse likely defense questions. Were you advised to return for follow up? Did you take your medications as prescribed? Anticipating this allows honest, composed answers. A calm, consistent witness often persuades more effectively than an emotional one. The expert witness carries the technical weight of the case. They must be able to trace every medical step, what was done, what was missed, and how that led to injury. This requires mastery of the records, understanding of hospital protocols, and familiarity with the standard of care at the time. The expert should base opinions on recognized guidelines or specialty references, avoiding personal bias. During testimony, the expert must explain the cause and effect relationships in everyday language. The blood loss was not detected early because vital signs were not checked, leading to shock. Calm authority and clarity under cross-examination are essential. The best experts educate the court, not argue with it. So these are the jurisprudence on medical injuries. The specific injury in relation to the case with complete citation. Now let's go to causation. Causation bridges the gap between breach and damage. The plaintiff must show that the physician's act directly caused the harm, not just coincidentally. Experts often express this as being more likely than not. For example, if a patient's infection resulted from a failure to maintain aseptic technique, that breach is the proximate cause of injury. Causation is hinge of every malpractice case. Even when a doctor commits an error, the law asks a deeper question. Did that specific act truly cause the harm? In Philippine law, we follow the doctrine of proximate cause, meaning the negligent act must set off a natural and continuous sequence that results in injury, without an independent cause breaking the chain. For example, if a physician failed to monitor post-operative bleeding and the patient went into shock, causation exists. But if the same patient died days later from an unrelated infection acquired elsewhere, the chain is broken. Courts use causation to separate bad outcomes from legally compensable negligence. It is the linchpin that turns a professional lapse into actionable malpractice. The starting point is a timeline from admission to discharge, showing every decision, test, and change in condition. This reconstruction allows you to pinpoint the exact moment of deviation from accepted care. After identifying the lapse, correlate it with the patient's subsequent deterioration. Each medical note, lab result, or order must logically connect the act to the injury. Finally, demonstrate foreseeability, that a reasonably competent physician should have anticipated the risk and acted to prevent it. Causation lives and dies in the paper trail. The most valuable records are those that show what happened and when. Admission and ER notes provide the baseline, how stable or unstable the patient was on arrival. Progress and nursing notes reveal whether the patient worsened and how quickly the team responded. Diagnostics often exposed omissions, an abnormal lab result that no one rechecked, or a radiograph that was never reviewed. Operative and anesthesia records detail minute by minute decisions, vital for tracing physiological decline. Referral letters and autopsy reports establish whether the handoff was timely or whether neglect continued. Together, these documents allow a reconstruction that either proves or disproves the causal chain. Medical causation is highly technical. That is why courts depend on expert testimony. The judge cannot assume that an act probably caused an injury without scientific explanation. The expert must articulate how the breach produced harm. For instance, because blood pressure was not monitored for 2 hours, hypoxia developed and led to irreversible brain damage. The law does not demand absolute certainty, only reasonable medical probability. This means that, based on science and experience, the injury more likely than not resulted from the doctor's negligence. Without this testimony, most cases collapse. A case can stand or fall on the credibility of its expert. Choose someone who practices in the same specialty as the accused. Courts give little weight to outsider testimony. The expert must clinically be active, familiar with both the technology and the realities of current practice. This prevents the defense from dismissing them as outdated or theoretical. Equally important is demeanor. The best experts are teachers, not advocates. They can distill complex physiology into simple cause and effect language. A neutral tone commands respect and builds trust. Finally, select someone analytical, able to integrate labs, notes, and timeliness into one coherent medical story that aligns with legal logic. Although one physician may serve in multiple roles, each expert has a distinct focus. The breach expert answers what should have been done. The injury expert answers what was the resulting damage. The causation expert ties the two. How did this act lead to that injury? In straightforward cases, say a retained surgical instrument, one surgeon may explain all elements. But in complex scenarios like multi-system failure or delayed cancer diagnosis, multiple experts like surgeon, pathologists, anesthesiologists create a stronger interlocking explanation. Their testimonies must complement, not contradict one another. What is the role of an expert witness? Clarifying the standard of care. The expert defines what a reasonably competent physician in the same field would have done under similar circumstances. They explain accepted medical practices, protocols, or guidelines at the time of the alleged incident. This is essential to establish whether the conduct in question deviated from the applicable standard. Establishing causation. The expert assesses whether the alleged act or omission caused or contributed to the patient's injury. They distinguish between expected complications of medical procedures and negligent acts that resulted in harm. In legal terms, this helps establish the nexus between breach and damage, which is a requirement for liability. Interpreting medical records and evidence. The expert reviews and explains complex clinical data, diagnostics, imaging, operative reports, and other records in accessible terms. They may point out inconsistencies, omissions, or errors in documentation. They can also assess whether the sequence of events described in the records align with medical plausibility. Educating the court. Since judges and tribunals are not medical professionals, the expert's role includes translating technical content into comprehensible language. They may testify on the nature of the disease or condition involved, risk and benefits of procedures, foreseeability of complications, whether the outcome was preventable. Offering a professional opinion. The expert provides an independent, unbiased opinion on whether there was a breach of professional duty, the standard of care was met or violated, the injury was avoidable or causally linked to negligence. In many jurisdictions, such opinions are required to initiate or sustain a malpractice claim. Assisting in damage assessment, especially in cases involving long-term injury or disability, the expert may comment on future medical needs, degree of permanent impairment, and prognosis and functional outcomes. Specialty alignment. The expert must be actively practicing or have recent clinical experience in the same or closely related specialty as the defendant. No. Their qualifications must align with the medical issue at hand. For example, an orthopedic surgeon for a femur fracture, not a general internist. Courts may reject opinions from experts who are not similarly qualified. Professional credentials. Board certification or its equivalent in the relevant specialty. Membership in reputable professional organizations, for example, the Philippine Medical Association, American College of Surgeons. Evidence of training, licensure, and continuing medical education. Experience with medico-legal work. Prior experience as an expert witness, especially in depositions, affidavits, or court testimony. Familiarity with legal standards such as burden of proof, standard of care, causation, and admissibility rules. Understanding of how to write medical legal reports and communicate effectively with non-medical audiences such as judges, lawyers, and tribunals. Impartiality and ethics. No financial or personal ties to any party that would compromise independence. There should be no record of unethical conduct or disbarment as an expert. Demonstrated willingness to testify objectively, even if the opinion does not favor the retaining party. Communication skills is the ability to explain complex medical concepts in clear jargon-free language. Experience with courtroom testimony, depositions, or tribunal appearances. Also, can remain composed and persuasive under cross-examination. Availability and responsiveness. This means the willingness to meet deadlines for written reports, deposition preparation, and court appearances. It also implies accessible to legal counsel for consultation throughout the case. Reputation and peer respect includes positive standing in the medical community. That there should be no history of malpractice or disciplinary actions if possible. It also involves recommendations from colleagues or legal professionals based on prior expert performance. Documentation skills includes the ability to prepare clear, well-reasoned, and defensible written opinions. Capable of reviewing and synthesizing extensive medical records, timeliness, and external guidelines, for example, the clinical practice standards. Familiarity with jurisdictional rules. This involves knowledge of the relevant and jurisdictions' procedural and evidentiary rules. Consistency and courtroom demeanor. Prior testimony history should be consistent. An expert who frequently changes opinions or is often disqualified may be viewed as unreliable. It means there must be demonstrable professionalism, integrity, and respectful conduct under questioning. Pre-testimony preparation of the expert witness. First, confirm the qualifications and admissibility. Review the curriculum vitae for accuracy, relevance, and completeness. Degrees, licensure board certifications, and affiliations. Ensure the expert meets jurisdictional admissibility standards. Address any past testimony or prior inconsistent opinions that may be challenged. Second is re-examine the case file and medical records. Have the expert thoroughly review all case materials, patient records, lab and imaging reports, clinical notes, operative summaries, other expert opinions or affidavits, plaintiff and defense statements. Prepare a chronology of events to anchor the testimony. Third is refine the written opinion. Review the expert's written report or affidavit for internal consistency, alignment with current clinical guidelines or literature, clear conclusions regarding standard of care, causation, and damages. Ensure explanations are accessible to non-medical audiences. like the judges. Fourth is conduct a mock examination. Perform a simulated direct examination using the actual questions likely to be asked in court. And emphasize stating credentials clearly and confidently, explaining medical terms in layman's language, emphasizing clear, definitive answers, avoiding overstatement or hedging, conduct a mock cross-examination to test composure under pressure, consistency with prior statements or documents, ability to handle challenges to qualifications or conclusions. Number 5, align on legal strategy. Clarify the legal theory of the case. For example, negligence, deviation from standard of care, proximate cause. Align testimony with key elements that must be proven or defended. The existence and breach of duty, the causation, but for and proximate, foreseeability and preventability. Coordinate with other expert witnesses to avoid overlap or contradiction. Six, prepare exhibits and demonstratives. Review and pre-mark exhibits the expert will use. For example, x-rays, graphs, clinical guidelines. Ensure the expert is familiar with visual aids and rehearse how they will be explained. Number 7, clarify courtroom procedures. Explain logistics such as who will ask questions first, when and how objections may occur, what to do if a question is unclear or inappropriate. Emphasize the importance of listening carefully to the question, answering only what is asked, pausing before answering to allow objections. Address potential weaknesses. Identify and review any vulnerabilities in the expert's analysis, gaps in documentation, conflicting medical literature, or alternative explanations. Prepare reasoned responses to anticipated cross-examination topics such as, aren't there differing opinions in this literature? Have you ever testified against a colleague? How much are you being paid? Number 9, review ethical and legal boundaries. Emphasize the expert's duty to the truth and the court, not to the party who retained them. Caution against expressing opinions beyond the scope of expertise or on legal conclusions. For example, that was malpractice. Reiterate the confidentiality obligations. Number 10, confirm availability and readiness. Confirm the following: dates for deposition or testimony, proper attire for court, understanding of courtroom etiquette. Ensure the expert has copies of the following: their report, supporting documents, a written timeline or outline if allowed. Now we'll go to the types of liability. So it could be the following: be criminal, civil, administrative. And a single act can result in simultaneous liabilities. The legal basis for criminal liability is Article 365 of the Revised Penal Code. The key elements are as follows: lack of intent but with reckless disregard for the consequences of one's acts. Number 2, a harmful result, which could be an injury or death. Number 3, a clear causal link between the act and the outcome. It punishes the act as an offense against the state, not just the individual harmed. For example, in a clear causal link between the act and the outcome, administering the wrong drug dosage despite obvious contraindications causing death. The penalty ranges from arresto menor to prisión correccional depending on the gravity of harm caused. For civil liability in relation to the doctor, the legal basis is Article 2176 of the Civil Code and also Article 2180 of the Civil Code. Article 2176 states that whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damage done. This article is the foundation of civil liability in quasi-delict, or in English law, tort. It applies to private wrongs that result in injury or damage and gives right to compensation separate from criminal prosecution. If civil liability is established, the court may award the injured party actual or compensatory damages for medical expenses, loss of income, etc., or moral damages for mental anguish, pain, and suffering. Exemplary damages if the negligence was gross or accompanied by bad faith, and attorney's fees and cost of suit. The civil liability for hospital is hinged on Article 2180 of the Civil Code, which states that employers shall be liable for the damages caused by their employees acting within the scope of their assigned task. So there are many bases for the civil liability in relation to hospitals. The doctrine of corporate negligence or institutional negligence is in essence, hospitals have a direct duty of care to patients independent of the physician's actions. They are not mere venues but active healthcare providers responsible for the quality of care and safety. The duties imposed on hospitals are the following: ensure proper credentialing and privileging of physicians, maintain safe and adequate facilities, equipment, and staffing, supervise the medical performance of staff, formulate, implement, and enforce policies for patient safety. Second is the doctrine of apparent authority or ostensible agency. When a hospital represents or allows a physician to appear as its agent or employee, and a patient relies on that representation, the hospital can be held liable for the physician's acts, even if the doctor is technically an independent contractor. So what are the key requirements? Number one, the hospital made a representation, whether express or implied, that the doctor was its agent. Number two, the patient reasonably relied on this appearance of authority. Number three, the patient did not have the opportunity to choose the physician independently. The doctrine of respondeat superior, or let the master answer. A hospital may be vicariously liable for the negligent acts of its employees committed within the scope of their employment. This applies when there is an employer-employee relationship between the hospital and the medical staff. The act occurred in the performance of assigned duties, and the act was not ultra vires, meaning beyond the scope of employment. The limitation, however, is as follows. It does not usually apply to independent contractor physicians unless modified by apparent authority or corporate negligence doctrines. Doctrine of informed consent. Hospitals may share liability when patients are not adequately informed about the risk of a procedure or treatment, particularly when the hospital fails to provide forms or mechanisms for ensuring informed consent. The staff assist or participate in procedures without patient consent. The doctrine of continuing duty of care. Hospitals have a continuing duty to monitor patient care even if the primary physician is an independent practitioner. The hospitals may be liable if they fail to intervene in deteriorating patient conditions, escalate care appropriately, or replace negligent staff. The doctrine of common enterprise or joint tortfeasorship. If the hospital and physician jointly participate in care, for example, through protocols, team-based interventions, and negligence arises from their collective action or inaction, they may be treated as joint tortfeasors and held solidarily liable. Lastly, doctrine of non-delegable duty. Some duties, such as ensuring patient safety, sanitation, and emergency response, are non-delegable, meaning the hospital cannot avoid liability by claiming the negligent person was a contractor or third party. Administrative liability. The bases are the following. Republic Act 2382 or the Medical Act of 1959 as amended. The RC Modernization Act of 2000, which is Republic Act 8981, and the Code of Ethics of the Medical Profession. All these are available online. Administrative liability. What are the grounds? The Board of Medicine may revoke or suspend a physician's license or impose other disciplinary measures on any of the following grounds: negligence or incompetence in the practice of medicine, gross misconduct or dishonorable conduct, conviction of a crime involving moral turpitude, use of fraud in securing the certificate of registration, addiction to drugs or intoxication, violation of the Code of Ethics of the medical profession, false or extravagant advertising, performing criminal abortions, unauthorized practice or delegation, and unethical conduct in professional dealings or referrals. What are the venue and procedure for administrative proceedings? First, you file a complaint before the Board of Medicine. An investigation follows. And in the investigation, if there is a prima facie case, there will be an administrative hearing. A decision will be rendered. And after the decision is rendered by the Board of Medicine, it can be appealed to the PRC or the commission itself. From the Commission, you can appeal to the Court of Appeals and then to the Supreme Court. What are the penalties? Penalties. First is reprimand for minor offenses or first-time violations. Suspension of license for a fixed period, for example, 6 months to 2 years, during which the physician may not practice. Third is revocation of license, permanent removal of the right to practice medicine in the Philippines. 4 is fine or censure, discretionary depending on the violation. And lastly, mandatory retraining or ethics education as part of remedial measures or conditions for reinstatement. What are the distinctions of liabilities? To summarize this, as to the purpose, for civil liabilities for compensation, for criminal, punishment, and for administrative, regulation and discipline. For the complainant, in civil cases, it's the injured party. In criminal cases, it's the state. And in administrative cases, the PRC and the complainant. Standard of proof is preponderance of evidence in civil cases, proof beyond reasonable doubt in criminal cases, and substantial evidence in administrative cases. Finally, in terms of penalty, in civil cases, it's damages. In criminal cases, it's imprisonment or fine. And in administrative cases, license sanctions. So this is a table of key doctrines, and some of which I have mentioned earlier. In closing, true medical care begins not with the prescription, but with the humility to ask, the patience to listen, and the discipline to doubt one's own certainty.